Good morning, friends. Let's deal with three interesting judgments of Honorable Gujarat High Court which have been delivered in this month of July 2025. In the first case, what has happened is that the assessee passed away and therefore the widow of the assessee filed return of income. Unfortunately, she declared husband's salary income into her return of income and claimed TDS. Ideally, the widow should have filed a return of income in the capacity of legal representative, and the salary income and TDS deducted should have been disclosed in that return. But unfortunately, she filed her own return of income, and in her own return, in her individual capacity, she declared the salary income of the husband and claimed the TDS. Of course, the TDS was deducted in the name of the deceased husband, so the 143(1) intimation was issued where the income of salary was taxed but the credit of the TDS was not granted. Assessee filed an application under section 154. It was also rejected. Finally, the assessee knocked the doors of the court. The Honorable High Court observed that this is precisely a case on account of ill advice. Further, in this case, as a matter of fact, widow did not have any taxable income which is required to be disclosed in her return. It was a very meager income of interest, so no other income was there. And so far as the husband's income, the deceased husband's income was concerned, it has to be disclosed in a return of income filed as representative. Admittedly, the assessee has committed a mistake by disclosing that in her return of income. So the Honorable High Court, exercising the powers granted under Article 226 of the Constitution of India, passed an order giving directions wherein the intimation issued under section 143(1) in the name of the widow, where the salary income was taxed but the TDS credit was not granted, that intimation was quashed, and the petitioner, that is the widow, was granted time to file the return of income in the capacity of legal heir, where she would be offering the salary income and would claim the credit of the TDS, and the respondent revenue was directed to grant the credit of the TDS. Of course, the Honorable High Court clarified that the petitioner would not be entitled to claim any interest on this refund arising on account of the TDS. The Honorable High Court followed a Supreme Court judgment wherein it has been held that the income has to be taxed in the hands of the right person. Let's deal with the second judgment for the day. What has happened in this case was the assessee has filed return of income. Thereafter, notice under section 148 was issued. As per the reasons for reopening, the assessee has made investment in immovable properties which have not been disclosed. The petitioner responded that as a matter of fact, the petitioner has sold immovable property and that has already been disclosed in the return of income. Since the reopening was based on incorrect facts, the Honorable Gujarat High Court was pleased to quash the reassessment. Now, the third case. What has happened in this case was the allegation was income was escaping assessment on account of applicability of section 2 clause 22 subclause E, that is dimmed dividend. It was argued on behalf of the petitioner, which was accepted by the Honorable High Court, that if there is a transaction which benefits both assessee, that is the director, or let's say the substantially interested shareholder, and the company both, then it does not fall in the category of dimmed dividend. Commercial transactions do not fall in the category of dimmed dividend, and that is a CBDT circular which was followed by Honorable Gujarat High Court. Following that circular and the Delhi High Court decision, the Honorable Gujarat High Court was pleased to quash the reassessment. I hope that this judgment would be of some benefit to you. With this note, I take a leave of yours. See you soon in the next video. Take care.